boom. I respect that you are respectful of your parents, so that's okay. What is this? Release for state-sponsored University Club Rugby was invalid. It's my own hair. Because when a state university provides recreational activities to its students, it fulfills its education mission and performs a public service. Other courts have incorporated the Tunkel factors into their decisions. The Colorado Supreme Court has developed a 4-part inquiry to analyze the validity of exculpatory agreements. 1. Existence of a duty to the public. 2. Nature of the service performed. 3. Whether the contract was fairly entered into. And 4. Whether the intention of the parties expressed in clear and unambiguous language. In the Jones case, the court concluded, based on the Tunkel factors, that no duty to the public was involved in air service for a parachute jump because that sort of service does not affect the public interest. Having reviewed these various formulations of the public policy exception, we accept them as relevant considerations but not as rigid factors that, if met, preclude further analysis. Instead, we recognize that no single formula will reach the relevant public policy issues in every factual context. So, the past few cases that have gone to court have used different factors to analyze liability, but the court doesn't strictly construe these factors, and the court is coming up with their own. It's just a meme. Trademark lawyers sit in office all day submitting forms. Yeah, that's actually what I did as a trademark paralegal. Submit forms all day, and I had so much fun. I'd be like on one of those drama law women, like who? Defendants urge us to uphold the exculpatory agreement on the ground that ski resorts do not provide an essential public service. They argue that they owe no duty to plaintiff to permit him to use their private lands for skiing, and that the terms and conditions of entry ought to be left entirely within their control. Because skiing, like other recreational sports, is not a necessity of life, defendants contend that the sale of a lift ticket is a purely private matter, implicating no public interest. We disagree. Whether or not defendants provide an essential public service does not resolve the public policy question in the recreational sports context. The defendant's area is a facility open to the public. Public policy context. D. Facility open to public. Thousands of people ride lifts, buy services, and ski the trails. At oral argument, defendants conceded that thousands of people buy lift tickets every day throughout the season. Each ticket sale may be, for some purposes, a purely private transaction, but when a substantial number of such sales takes place as a result of the seller's general invitation to the public to utilize the facilities and services in question, a legitimate public interest arises. Imagine getting to an argument with me and I start pulling out documents, presents evidence in a strong debate. Oof. I actually used to be extremely argumentative when I was younger, and now I'm really not the opposite of argumentative. If somebody wants to argue with me, I just walk away. Wonder who won the case, the company or the guy that got hurt. I know, I'm still reading about it. The major public policy implications are those underlying the law of premises liability. In Vermont, a business owner has a duty of active care to make sure that its premises are in safe and suitable conditions for its customers. We recognize this duty of care where the defendant's routine business practice creates a foreseeable hazard for its customers. The business invitee has a right to assume that the premises, aside from the obvious dangers, are reasonably safe for the purpose of which he is upon them, and that proper precaution has been taken to them so. We have already held that a ski area owes its customers the same duty as any other business to keep its premises reasonably safe. So, premises liability, reasonably safe. Premises liability, business invitee should expect a reasonably safe place. Giant cup for a tiny person. Oh my gosh, it looks huge, huh? It's normal. If you want to argue with me, you have to pay money for my time. I really don't like arguing. I mean, debating is fun, but I feel like arguing has that negative connotation, and people start using like ad hominem arguments. They start attacking you about things that aren't even relevant, and it's just unnecessary. The policy rationale is to place responsibility for maintenance of the land on those who own or control it, with the ultimate goal of keeping accidents to the minimum level possible. Defendants, not recreational skiers, have the expertise and opportunity to foresee and control hazards and to guard against the negligence of their agents and employees. They alone can properly maintain and inspect the premises, train the employees in risk management, blah, 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 blah. The defendants were permitted to obtain broad waivers and achieve incentive. An important incentive for ski areas to manage risk would be removed if the public bearing the cost of resulting injuries. Broad waivers lead to Iron Beast, good morning. If someone starts using any logical fallacy, they go on the debate period. True. Thanks for the follow, dude. Broad waivers would lead to an important incentive for ski areas to manage risk would be removed. Would lead to ski resorts not removing risks and public bearing cost. It is illogical in these circumstances to undermine the public policy underlying business invitee and allow skiers. A recognition of the principles underlying the duty to business invitees make clear the inadequacy of relying upon the essential public service. Moreover, reliance on the private nature of the defendant's property would be inconsistent with societal expectations about privately owned facilities that open to the general public. Indeed, when a facility becomes a public place of accommodation, it renders a service which becomes a public interest. Place of public accommodation. Defendants argue that the public policy of the state, as expressed in the acceptance of inherent risk statute, indicates a willingness on the part of the legislature to omit ski liability area. Therefore, they contend that public policy favors the use of express releases. On contrary, defendants' allocation responsibility for skiers' injuries is at odds. The statute places the responsibility for inherent risks of any sport on the participant, insofar as such risks are obvious and necessary. A ski area's own negligence, however, is neither an inherent risk nor an obvious and necessary one. Thus, skiers' assumption of the inherent risks of skiing does not abrogate the ski area's duty to warn of or correct dangers. The company lost. Thou shalt not commit logical fallacies. Good morning, Josh. How are you doing? I'm frozen. Are you guys there? My screen is frozen. Y'all there? Hello? I am there, right? Okay, I think so. Just kick a tree in a ski place. Not necessarily that. My internet be wildin'. I know. I don't know why. I had to check my phone connection after stream. And maybe I'm signed into like the wrong network. Good morning, Emperor. How are you? My face is frozen like Asian jeans. Oh no. The company lost because they can't just have a big liability waiver and not be responsible for injuries occurring on their premises if it's something that they could have taken care of. And because it is a ski resort is a private place, but if you open it up to the public, now it's a public place of accommodation. So then you have to, how do I explain this? Yeah, so now that it's a public place of accommodation, then it's a matter of public interest, and they want like safety standards. When does my day end today? My day or my stream? Am I still frozen? It's like really bad. Shit. My FPS is like 20 something. Good, you're off, so you're gonna sleep in, but your pupper's going crazy. Aww. It just glitches every now and then. I'm sorry guys, I will fix my connection for next time. But if I fix it now, I think I'll be gone. Just a stutter from time to time. Sorry about that today, guys. I love puppers, me too. Me too. So this one is Senor V National Fitness Institute, Inc. I'm tired of reading out loud. Let's put a pin in it. Thanks for being understanding, guys. Vanish, hey, how's it going? Okay. Oh. Revise towards syllabus. Oh no. Why? Which means more homework. Please note that I've added document 17-0A to chapter 17 of the Kane folder. It is on vicarious liability, and I plan to cover the material at the beginning of next Monday's class. Leaves home because I won't get as much done. Proceeds to distract herself with stream. I know, it's so bad. It's okay. I think we got one case done. Oh my god, it's 8:47. Did it take me 47 minutes to read one case? That's actually pretty bad. supplemental jurisdiction. If supplemental jurisdiction is solely on 1332, then jurisdiction except if rules 14, 19, 20, or 24. Res judicata, one and done. A matter adjudicated once cannot be pursued further by same parties. I should host someone at end of stream if I want. I should start doing that actually. Thanks for being your lawyer. I keep forgetting. The coffee positioning, my bad you guys. Yesterday, Razor Cortex was reporting your FPS is like 3. Oh gosh. If you have any friends that you want me to raid, let me know. Yeah, the rule of thirds. Okay. I should work on my outline. Yes, my outline. What am I gonna do when my laptop dies? No, my laptop is not going to die. Contracts, outline. Hello? Okay, there it is. And also chart, contracts rules, not most wanted. Hey, good morning, how's it going? Not most wanted. Who else can teach us about the law? Have fun hanging out. Thanksgiving dinner. Oh, thank you. It's gonna be great. I'm really looking forward to it. Not most wanted, thank you so much for the follow. Hey, dad joke, did you laugh? Totally. So you'll never have like a mock trial or anything yet? I don't know. I thought about doing it for extracurricular activities, but it's not really my thing. At you, not with you. Ouch. You're hilarious. Ha. You guys ever go LOL and you're just sitting there like, or you go LMAO and you're like texting, but like you're just sitting there and you're not laughing? I messaged one of my friends in class and he put LMAO and I looked at him and I was like, you're not laughing, I'm staring right at you, you fucking liar. So, outline time. Yeah, every time. Exposed, super exposed. We'll see. I'll update you if I end up trying it out or not. If you type LOL, that means you're laughing, period. My book is so fucked up. Hello, chat. There you are. What was I reading? I don't remember. Hey, Dub. How's it going? If you type LOL, you're not laughing. If you type LOL, then you're laughing. So that book is basically full of trials. Yeah, it's a case book. So it's full of past cases that we're exploring, and then it sets a precedent for future cases. What am I studying? I'm a first year law student, and I was studying tort law, and now I'm studying contracts. You're a media guy. Ooh, nice. What do you do? do you film? Do you... I don't know very much about media. Where's my internet? You're trying to understand this because it's pretty applicable. Precedents can be thrown out by the judge of a higher court, though, right? Depends. Yeah, it could possibly be thrown out. It could be modified. So, oh, mistake. Did I put 376 in here? I did not. 376. And 376 is, so I have like charts and outlines of like my course material that I kind of have like that I do to take notes, I guess. So now I'm just updating my stuff. Availability of damages. How is school? School's great. I love school. I'm having a fun time. You do video editing, but you want to try film. Oh, I see. Oh, no worries. That's cool. Adult film media, for sure. Emperor. $208. Wait. The injured party has a right to damages for any breach by a party against whom the contract is enforceable unless the claim for damages has been suspended or discharged. If the breach caused no less... I'm dropping frames still? Keeps happening. Your Wi-Fi be trash. No, I really think it's mine. If the breach caused no less, or if the amount of the loss is not proved under the rules stated in this chapter, a small sum fixed without regard to the amount of loss will be awarded as nominal damages. If the breach caused no loss, or if the amount of loss is not proved. Okay. So, injury equals damages, and then nominal damages. Got it. Want to come over and study? Did you know when people ask you to come over and study, they don't actually want to study? I can film and edit, right? Because you film and edit. Netflix and chill. People are fucking liars, dude. Like, you didn't want to study. I'm going home. That's also happened with, hey, you want to watch a movie? I'm like, yeah, oh my gosh. Now I'm just like, I don't watch movies. Study anatomy, what do you mean? I'm not a science major. I don't need to study anatomy, thank you. Insert rows below. That is. You never want to study, you're just trying to get some ramen. Oh, I love ramen. I fucking love ramen. I fucking love ramen. Hey, wanna watch a movie? Never. I actually don't like movies. I like books. I like some Netflix shows, but I don't like movies. I can't sit there for 2 hours. Unconscionable contract term. Or term. And what does that mean? If a contract or term thereof is unconscionable at the time the contract is made, a court may refuse to enforce the contract, or may enforce the remainder of the contract without the unconscionable term, or may so limit the application of any unconscionable term as to avoid any unconscionable result. What the fuck does that mean? You think study anatomy together is a euphemism? I didn't know that a lot of the time. Want to read a book together? Oh my god, yes! I actually have book clubs with my friends, and we would read the same book, and then we would talk about it. And we'd ask each other like, hey, did you get to this part yet? Okay, let me know when you get there. And then like we'd talk about it. Damn it, Upper! Almost spat coffee on my screen. J-Pop, thank you so much for the follow. We are not studying hard law. 50 Shades of It's an Asian thing. You guys are terrible. You guys are the reason why I don't study with people. Illegality, 178. Insert columns below. 178. Yo, type. I need flashcards. When a term is unenforceable on grounds of public policy. When a term is unenforceable on grounds of public policy. Wait, UCC 3, 175 and 176. Oh shoot. Insert rows below. Insert rows below. 175. Who is Soyu? Oh my god, it's one for you. I totally forgot, Boom. Chat's super busy and lewd today, right? If there's something that is deemed unreasonable in a contract, the court can void said contract. I think that's what it's saying. Ah. Like if a contract said, you're my slave now. It's Wednesday, my guy. Most active chat, no doubt. Adult novels. Are we really doing this? Boom, a real... I know, Boom, you're a real one. My god, you guys are wild today. Bye, Robot. Thanks for hanging out. 175. When duress by threat makes a contract voidable. We did go over that. When, oops. 175. When duress by threat makes